6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
What happens when a grown man with no connection to a school enters a boys' locker room, refuses to leave, and then allegedly moves to the girls' locker room? Today, we're breaking down a criminal trespass case that has everyone on edge. A defendant who walked into Emory Wiener School without permission, started talking to students in their locker room, and had to be forcefully removed by security. The prosecution is demanding GPS monitoring, internet restrictions, park bans, and even home confinement, calling this a dangerous case that affects children and the community. But here's the twist. The defendant hasn't been charged with any sex crime or child-related offense, just criminal trespass. So the question becomes, how far could a judge go in restricting someone's freedom when they're only accused of being somewhere they shouldn't be? We've got a judge who's fiercely protective of children, a prosecution team pushing for maximum restrictions, and a defendant who's about to learn that even a misdemeanor charge can result in life-altering conditions. From GPS ankle monitors to internet bans to stay-away orders from every school in the county, this case shows exactly how the justice system responds when children's safety is potentially at risk. Buckle up, because this is about to get intense.
Okay.
On September 18, 2024, a law enforcement officer was dispatched to a citizen holding call or a citizen holding suspect call at 9825 Stella Link Road in Harris County, Texas. The law enforcement officer made contact with the complainant. The complainant, a coach at Emory Wiener School, stated that he witnessed the defendant inside of the boys' locker room talking to students. The complainant told the defendant to leave and not to interact with the students, which the defendant refused. The complainant stated that security guards entered the locker room and forcefully removed the defendant. The law enforcement officer observed the defendant detained in front of the boys' locker room and was identified with his Texas driver's license.
Let's stop right here and break down what's actually being alleged, because the facts of this case are deeply concerning and raise immediate red flags. We have an adult male, not a parent, not a teacher, not a staff member, not a student, who entered a school's boys' locker room and was found talking to students. When a coach discovered him and told him to leave and not interact with the students, he refused. Think about that for a second. A school employee gives a direct order to someone who has no business being there, and the person refuses to comply. That refusal is what transformed this from a simple misunderstanding into a criminal situation. It took security guards physically removing him from the premises. Now, at this stage, he's only charged with criminal trespass, which is a Class B misdemeanor punishable by up to 6 months in jail and a $2,000 fine. But the concerning nature of the conduct, specifically being in a children's locker room and refusing to leave when confronted, is what's driving the aggressive prosecution strategy we're about to see. The prosecution and judge are clearly worried that this behavior could be a precursor to something more serious, even though he hasn't been charged with anything involving children specifically. This is where the tension arises. How do you balance protecting children from potential danger against the constitutional rights of someone who's only been accused of trespassing? The probable cause affidavit doesn't tell us why he was there, what he was saying to the students, or what his intent was, and that ambiguity is making everyone extremely cautious.
Mr. Williams, you're not a student there or a teacher there, are you? Okay, don't go back to Emory Wiener. Holy moly, if I find that you go back to a school or is it an elementary school? It's like a high school, isn't it?
I believe it's a middle school. Let me double check.
Do you have any children? I'm ordering you not to go to any high school, any middle school, any elementary school whatsoever for any reason. Not to have contact with anyone under the age of 15. And if you do, I'm going to put you in jail. Do you understand?
I guess it's a mixed school. They serve grades 6 through 12.
How old are you, Mr. Williams? What do you do for a living, sir? Okay. I'm going to tell you now that my sole purpose in life is to protect every single child in this county. And if I find that you become a danger to anyone, I'm going to make your bond so high, you're going to have teeth falling out. Do you understand, sir? No contact, and I'm absolutely serious.
Now we're seeing the judge take immediate and aggressive action, and his tone leaves absolutely no room for misunderstanding. He's imposing sweeping restrictions that go far beyond the typical conditions for a criminal trespass case, and he's making it crystal clear that violating any of these orders will result in immediate incarceration. Let's break down what he just ordered. First, Mr. Williams is banned from every high school, middle school, and elementary school in the county. Not just Emory Weiner where the incident occurred, but every school for any reason. That's an extraordinarily broad restriction. Second, he's prohibited from having contact with anyone under the age of 15. That's a massive limitation on someone's freedom, especially if they have family members, neighbors, or legitimate reasons to interact with minors. The judge's justification is clear. He sees his role as protecting children above all else, and he's willing to impose harsh consequences to ensure safety. Notice his threat about bond. If Mr. Williams becomes a danger, the judge says he'll set bond so high you can have teeth falling out. That's judicial language for, I will make sure you cannot afford to get out of jail. What's fascinating here is that these conditions are being imposed at probable cause hearing, not after conviction. Mr. Williams hasn't been found guilty of anything yet, but he's already facing restrictions that would typically be reserved for registered sex offenders or people convicted of crimes against children. Is this appropriate judicial caution, or is it an overreach based on suspicion rather than proven facts? The judge clearly believes a potential risk justifies the restrictive measures.
How much money do you make a month, sir? Okay. We're going to reset your case to give you time to hire a lawyer. So for now, I'm going to have you go to Victoria, sign a reset. After that, I'll have you take your seat in the jury box while we get your bond conditions. We'll have you sign it.
Judge, can we also ask for restrictions to parks?
So are you here on this case?
I'm not, Judge. I just have to look at the probable cause.
Tell me, what do you got?
Well, based upon the probable cause, Judge, the state would recommend restriction to any parks where children can be normally at play, and restriction to internet access in order to prevent any type of interaction.
Here comes the prosecution's wish list, and they're asking for restrictions that would fundamentally alter every aspect of Mr. Williams' daily life. They want him banned from parks where children normally play, and this is the big one. They want to restrict his internet access. Let's talk about how extraordinary that second request is. Internet access in 2024 is not a luxury. It's essentially a necessity for modern life. Banking, employment applications, communication, navigation, news, shopping, paying bills. Almost everything requires internet access. Restricting someone's internet use is typically reserved for convicted sex offenders, people involved in cybercrime, or individuals who've demonstrated they're using the internet to commit crimes or endanger children. But Mr. Williams hasn't been convicted of anything, and there's no allegation in the probable cause affidavit that he used the internet inappropriately or that his trespass involved any online component. The prosecution's argument is preemptive. They want to prevent any type of, and notice they don't even finish the sentence, but the implication is clear. They're worried about potential child exploitation or predatory behavior. The park restriction makes more logical sense given the allegations. If he's accused of inappropriately being around children in a school setting, keeping him away from places where children congregate is a reasonable precaution. But banning internet access based purely on suspicion? That's a massive restriction that could prevent him from working, managing his finances, or functioning in society.
But I am not on this case.
No, yeah. Well, I mean, I want to protect all children, right? If he was charged with something like a child pornography, then absolutely, right? But he may have a lot of business on internet, banking, mortgage, just parks, okay. Internet, I don't know. I think that might be,
Yeah. And now we see some rare judicial restraint and critical thinking from the judge, which is honestly refreshing given how aggressive prosecution is being. The defense attorney, or someone in the courtroom, points out the obvious. If Mr. Williams were charged with child-related offense, internet restrictions would absolutely make sense. But he's not. He's charged with criminal trespass. The judge acknowledges this distinction and raises a practical concern. The defendant may have legitimate business reasons to use the internet. Banking, mortgage payments, job searching, communication. Completely cutting off someone's internet access could actually make it harder for them to comply with other court conditions, like maintaining employment or paying fines and fees. Notice the judge's hesitation when he says, "Internet, I don't know, I think that might be, He trails off, but you can tell he's uncomfortable with imposing such a sweeping restriction without more specific evidence that internet access poses a danger. This is an important moment because it shows that even judges who are deeply committed to protecting children recognize that bond conditions have to be proportional to the actual charges and allegations. You can't just throw every possible restriction at someone because you're worried about what they might do. You need evidence that specific restrictions are necessary to protect public safety. The judge ultimately decides to impose a park restriction, which directly relates to the allegation of being around children inappropriately. But he's clearly skeptical about the internet ban. That's good judging, balancing safety concerns with constitutional rights and practical realities.
You see what they want me to do, Mr. Williams, right? And I'm going to tell you now, if I were to limit your internet access, your life would be it would just be a lot more difficult. I don't want to make your life difficult, but at the same time, I want to protect every single child here. And I'm going to do everything I need to do it. Do you understand? So if I find that you're acting a fool out there in the free world, however it may be, you saw me just now put someone else with a $50,000 bond. I mean, I have no problem making it $500,000. I've done it before and I'll do it again. So just beware when you're out there, make smart choices. Do you understand? Okay, so no parks or places where children can go.
Any devices?
Devices, guys?
I'm sorry, Judge.
Device?
Most definitely a GPS device with an exclusion zone, Judge. At that.
I think I agree with that as well, but I'll waive the fee so he doesn't have to pay for it.
Judge, we would ask for
yeah.
a whole conf-
Now the judge is implementing what might be the most significant restriction of all, GPS monitoring via ankle bracelet. This is a huge escalation from typical misdemeanor trespass cases, and it's worth understanding exactly what this means. GPS monitoring devices track a person's location 24 hours a day, 7 days a week. If Mr. Williams goes anywhere near a school, park, or restricted location, the monitoring company will know immediately and alert authorities. These devices typically cost between $500 and $600 per month, which the judge acknowledges and agrees to waive, meaning the county will pay for it rather than requiring Mr. Williams to cover the cost. That's actually a significant concession because in many jurisdictions, defendants are required to pay for their own monitoring, which can create a debtor's prison situation where people can't afford to comply with their bond conditions. The judge is being strategic here. He wants the monitoring in place to ensure compliance and protect children, but he doesn't want costs to be an excuse for violation. He also issues a stark warning. If the battery dies on the GPS device, Mr. Williams goes straight to jail, no excuses. These devices require daily charging, and failure to maintain the charge is treated as a violation of bond conditions. The judge is essentially saying, I'm giving you the technology to prove you're following the rules. I'm paying for it, but you have to take responsibility for keeping it functioning. What's notable is that GPS monitoring is typically reserved for serious felonies, repeat offenders, or cases involving significant public safety concerns. Yet here it's being imposed for a misdemeanor trespass case, which shows just how seriously the court has taken the child safety angle.
confinement as well.
Well, I'm not going to do home confinement. He's got to work. That would seriously, he said he doesn't have children.
Could we request some sort of proof from the judge so I know that he's not misrepresenting the court or saying no home confinement, because this is a dangerous case, Judge. And part of the community is affected by this case. Children were affected. He goes into the boys' locker room, refuses to leave. Then when he says he's going to leave, he goes to the girls' locker room. And yes, Judge. Yes, Judge. It's a very dangerous case and the community was affected.
Wait, hold on. This is the first time we're hearing that Mr. Williams allegedly went to the girls' locker room as well, and that's a bombshell that completely changes the context of this case. The prosecution just revealed that after being told to leave the boys' locker room, he allegedly went to the girls' locker room. If that's true, it demonstrates a pattern of deliberately seeking access to spaces where children are in vulnerable situations, changing clothes, showering, in states of undress. That's not a simple trespass mistake. That's purposeful and predatory-looking behavior. The prosecution calls this a dangerous case and argues that the community and children were affected. They're pushing hard for home confinement, which would essentially require Mr. Williams to stay at his residence except for work, medical appointments, or court appearances. The judge pushes back, noting that he needs to work and that home confinement would seriously impact his ability to earn a living. This is where the tension between public safety and individual liberty becomes most apparent. The prosecution sees a potential predator who deliberately targeted children's locker rooms and should be locked down as tightly as possible. The judge sees someone who hasn't been convicted yet and needs to be able to work and support himself. The fact that this new information about the girls' locker room is only coming out now raises questions. Why wasn't it in the original probable cause affidavit? Was it in a police report that wasn't read aloud? Or is the prosecution embellishing to justify harsher restrictions? Either way, if it's true, it makes the case significantly more concerning than a simple trespass.
Yeah, and then going within, 500 feet of any school, elementary school. Yeah. I'm putting a monitor on you so I know where you are, because I'm not going to take your word for it. Understand, if the battery dies, so will you. You have to charge it on a daily basis. That thing costs around $500 to $600 a month. I'm going to pay for it for you so that there's no excuse. But you need to understand that you're going to have to charge that thing on a daily basis. And if the battery dies, that's it. I'm not going to entertain any excuses. Do you understand? Now, I'm not going to require proof of employment, but I'm going to take your word that you're a working man, that somehow you need to survive. But just, you're walking and skirting a very short leash here. Do you understand, Mr. Williams? Okay. Well, don't. You have the right to remain silent. I've got a ton of DAs here, and everything you say, they're going to use it again. They're going to, use it against you. And I want to protect you as much as I can within the, bounds of the law. Do you need me to appoint you a lawyer?
I do.
Okay. I'll have him fill out an application. Yeah, I guess no drugs, no alcohol as well. Yeah. I will provide you a lawyer today. They'll be able to counsel you on how to move forward, but no drugs, no alcohol. You know what the other conditions are. They want me to make you stay at home. I don't want to have to do that. Just, you understand what's expected of you, right?
Yes, sir.
Okay, man. All right. I'll have you sign a receipt.
And there you have it. One of the most restrictive sets of bond conditions I've seen for a misdemeanor trespass case, and it's all driven by legitimate concerns about child safety. Let's summarize what just happened and why this case is so significant. Mr. Williams walked into Emory Weiner School, a mixed school serving grades 6 through 12, entered the boys' locker room, was told to leave by a coach, refused, and then allegedly went to the girls' locker room before being forcibly removed by security. He's been charged with criminal trespass, a Class B misdemeanor, but the conduct alleged is so concerning that the judge imposed conditions typically reserved for serious felonies or sex offense cases. The final bond conditions include a 500-foot stay-away order from all schools, a ban on contact with anyone under 15, prohibition from parks and places where children gather, GPS ankle monitoring paid for by the county, a requirement to charge the device daily or face immediate jail, no drugs or alcohol, and appointment of a public defender. The judge declined to impose home confinement or internet restrictions, showing some restraint, but made it absolutely clear that any violation will result in massive bond increases or immediate incarceration. What makes this case so interesting is the tension between protecting children from potential harm and respecting the constitutional rights of someone who hasn't been convicted. The judge clearly believed the allegations are serious enough to warrant extraordinary precautions, and his warning that he's willing to set bond at $500,000 shows just how committed he is to child safety. But we also have to acknowledge that these restrictions are being imposed based on probable cause, not proof beyond a reasonable doubt. Mr. Williams hasn't had his day in court yet, hasn't been able to present his side of the story, and we don't know why he was there or what his intentions were. The prosecution called this a dangerous case and emphasized that children were affected, but until there's a trial or plea agreement, we're operating on allegations. What's your take on this? Do you think the judge struck the right balance between protecting children and preserving the defendant's rights? Should someone charged with misdemeanor trespass face GPS monitoring and such extensive restrictions, or is this appropriate given the nature of the allegations? Drop your thoughts in the comments below. I'm genuinely curious to hear different perspectives on where the line should be drawn. And if you found this breakdown as thought-provoking as we did, make sure to hit that like button, share this video with anyone interested in criminal justice and child safety issues, and don't forget to subscribe for more in-depth courtroom analysis where we break down real cases, explain complex legal issues, and show you exactly how judges balance competing interests in the justice system. We got more fascinating cases coming your way, and trust me, you won't want to miss them. Thanks for watching, and I'll see you in the next one.